Welcome to the Ownership Economy Podcast, the podcast that explores the people and ideas that are utilizing technology, economics, and the law to reimagine how the economy can work for everyone. Here we connect with the entrepreneurs, investors, thought leaders, academics, and politicians that are constructing the ownership economy by expanding access to broad-based ownership and democratic governance. I'm Martin Smith, and I'm joined by my co-host, Jahed. We are two investors and operators that aim to use this platform to showcase the people and ideas that will shape a society that offers more economic opportunity for all. Today, we are joined by Jason Wiener, founder of Jason Wiener PC, a law firm that specializes in ventures, organizational design, and cooperative law. He's a co-founder of Main Street Phoenix Worker Cooperative, a venture that is building an employee-owned restaurant group. He also serves as a board member of Stocksy United, a rare, profitable, and growing digital platform cooperative co-owned by the photographers that utilize the platform. So Jason, welcome. We're happy to have you here. So you're an expert on legal support for cooperatives, blockchain initiatives, DAOs, and many other forms of organizations. Let's really dive into that. It's a super complex space with constantly moving regulatory initiatives and innovations. Why don't you walk us through how you got started and kind of your origin story?
Well, thanks, Martin. Thanks, Jahed, for having me. It's really exciting to be here and talk to you both about these subjects. The first I'll say is I'm here representing my firm that has organizational expertise in these areas. My specialty is in cooperative finance and securities, and I'm adjacent to the blockchain and DAO work that our firm does through my colleagues Yev Muchnick and Jacqueline Radebaugh. I got started really as an in-house attorney. I was at Big Law in New York City, and I went in-house for a solar company that started out employee-owned, but this was in 2008, 2009, really before the kind of organized social revolution around ownership design really came into the forefront. It was one of the more recent rebellions against traditional hierarchical extractive capitalism. The Great Recession brought me out here, but I stayed because we built and then got to surf the wave of broad-based ownership and alternative finance. In my capacity as an in-house lawyer, I really was required to become creative and design legal strategies as opposed to just showing up to the leadership table and saying no to things. So I had to look at all the kind of innovative stuff that entrepreneurs were bringing and wanting to do differently, whether it was around corporate governance or finance and fundraising, or even just basic transactional work. So I've been associated with the Teal legal movement. I've been associated with the alternative finance and social finance sector. But really my passion and deep working knowledge is in the cooperative and alternative finance space. I'm not really a dogmatic person, and I think I've worked to push the envelope on what cooperatives can do, how to make them more generally applicable, and then how to use traditional and non-traditional finance to support those efforts. And I kind of operate along all those dimensions.
Great. You've had kind of a fascinating career, and we've known each other for a long time now. And so one of the things that you mentioned was broad-based ownership. And so that, for people that aren't in the field, broad-based ownership essentially, and correct me if I'm wrong, is, entities where a significant portion of the cap table are owned by traditionally employees, right? And much of the ethos of the Web3 space can actually trace its origins to cooperative design. But in many ways, the cooperative entity is being unbundled, allowing for organizational designs that choose different ownership and governance strategies. And from what I've known from kind of just knowing you over the years and your work is that you really like to keep a number of those governance and ownership rights bundled. And so what do you think that the cooperative entity can bring to Web3, and what are the limitations of the cooperative entity, if any, in your opinion, when it comes to Web3?
Yeah, I don't know that the genesis of Web3 traces back intentionally, but I think we're discovering or rediscovering the cooperative time and again. First, I saw that after 2008, 2009 as an antidote to extractive investor-owned capitalism. And we're seeing it now with Web3, really looking at participatory structures and looking at distributed finance. And in many ways, that's getting to what are cooperative core principles and also part of the core design of cooperative entities, which is democratic governance and participatory economics. And Web3 brings a layer of technology and distribution and transparency. And I think there are inherent limits in Web3 design because they lack the kind of robustness of legal wrappers that have made cooperatives accountable structures. And I think we should be somewhat skeptical of replacing legal accountability for technological accountability. There are, I know blockchain holds tremendous promise around distributed power and, ledger transparency, but there's a lot that we don't know about it. And I think the kind of legal ethics of blockchain and DAOs really just need to be explored rigorously because the space is moving fast. And at least in the law, nothing moves fast. And, often entrepreneurs malign that as the legal industry and legal norms being kind of Byzantine and reactionary. But in truth, the value there is that we get to see a broader fact pattern emerge to make sure that the legal system is capable of holding the desired public policy benefits within it. And so I think when we look at things like securities, compliance, and organizational structures, these have been around for hundreds of years. The cooperative has been a legal entity type in many parts of the world for, more than 200 years. And you need to honor that history because it served many, many different purposes while enabling broad-based wealth sharing and access. And the lesson that I hold is that when technology moves so much faster than the law, there's a practical issue there, which is that the law often, is created as a pendulum swing the other way. Regulation will hold back and get designed around bad actors. And this is a hard thing to constrain because we're often not talking about, human action that's giving rise to some of the legal risks. So I think, one might look at the cooperative as a limitation because of its legal robustness. And yet I would argue that that legal robustness gives clear guidelines and creates clear accountability and vests what is currently a technological process as a legal responsibility for people. And ultimately, that's what any organization is. An organization is made up of people at some level. And, there's just a lot of risk associated with, anonymizing and kind of tokenizing every aspect of an organization. At its root, a DAO is an unincorporated association or partnership, which creates, in most places, unlimited joint and several legal liability. That's the fundamental premise that gave rise to the joint stock company in the 1700s because it's so inherently risky. And we haven't yet seen mainstream publicized models of these things getting unraveled by regulators or legal claimants, but I don't think we're far from that day.
Interesting. And so when we think of a DAO, we think of kind of, this group of individuals that come together around a particular entity to co-create together. There's been examples of people purchasing assets. There's been examples of venture funds created. There's been examples of, all sorts of different, it's almost like I like to think of it as kind of the blockchain-based, de Tocquevillean association, right? But at the same time, there really isn't, what are most of these DAOs, right? If they're not set up properly, ultimately, they're not really an organization, right? They're a Discord server. And so when you've done work in this space and your firm has done work in this space and someone wants to set up a DAO and they come to you, how do you recommend that they go about that? And how is that different from setting up a traditional cooperative?
Well, the first thing to realize is this gets back to first principles under the law. And I think we've been quick to embrace the DAO vocabulary and norms as a fait accompli. They are here because they are, and it's exciting. And what I think needs to be really appreciated is that all of these relationships and activities have an analog under existing law. And I think we can put a bunch of new names and a bunch of new media in between these relationships. What used to be a relationship between people either by handshake or by written instrument is now a digital reflection of a relationship, in a blockchain that is, kind of ledgerized and has become transparent. But we've had this problem before, and we can trace it back to the precursor to the formation of legal entities. And legal entities are considered under at least US law separate persons for lots of different reasons. What a DAO is before it's actually formed under the law of a jurisdiction, it's an unincorporated entity. It is, for many intents and purposes, either an association or a partnership. And what makes that risky is that an association or partnership puts each associate or partner on the legal hook for debts, liabilities, and obligations of all other partners or any other partner or the association itself. And so to the degree that there's any legal consequences or jeopardy or claim made against a DAO or its members, without a legal wrapper to limit that liability, that flows through to its partners. The legal entity is not a recognized separate person. So over the last 200 years, we've created legal structures to shield those principals and investors from liability. That's the entire idea behind limited liability protection, so that investors and principals are shielded in their business risk or associative risk from the debts, liabilities, and claims of other participants and of the entity itself. Without a legal wrapper in any jurisdiction, claims can be made in many places because these things don't live in, the physical world. They live in, the metasphere, the ethosphere, wherever. And, claims are lodged in the real world. And courts still can exercise jurisdiction. So without a legal wrapper, these things essentially are ill-defined, nebulous, amorphous constructs with joint and several personal liability. So I would say that the first thing is to really understand, and any time an entity is governing or managing assets, that's a very real risk to manage, right? It's not just the value of assets in treasury or something like that. It's every decision that's made with and around that asset. It's every activity that's exercised by the DAO. And I think, we can't just discount 250 years of corporate jurisprudence and say that it's, permissive and it's exclusionary, and therefore we're going to just do an end around the law and create these permissionless distributed entities and avoid all the conventional problems. The conventional problems are themselves construct of claims made by people of these associations. Remember, the law is always a reaction to controversies brought by people in court. It's the evolution of norms based on fact patterns. The facts haven't changed that significantly. The technology has. And so I think it's critically important that we nest these DAOs in enforceable legal structures to provide the level of protection and organizational accountability that's warranted by the activities and assets of the DAO.
One of the things you mentioned is that not that much has changed. Why do you think the SEC and the other regulatory bodies in the US are having such a hard time kind of enforcing traditional regulations here against both, Web3 companies that are set up as traditional companies, but then using tokens, and then now DAOs that are using kind of a more distributed governance or more kind of democratic governance system? What is the challenge here for the SEC?
Well, my response is kind of at 80,000 foot level. The SEC is a regulatory body that's underfunded and under-resourced, and it's a remedial agency that's looking at protecting the public interest based on a highly complex set of statutes and regulations. And its first challenge is to understand the facts. What are these things? How are they managed, governed? And they've then got to kind of juxtapose those facts under their legal regime. And the legal regime was built 85, 90 years ago, 1933, 34, and 1940, respectively, with a series of regulatory updates over the years. But this is what agencies do. This is what the law does, is it says, okay, here are the facts as we currently understand them. And remember, those facts are changing all the time. The vocabulary is foreign to many of us. And they've got to juxtapose those facts under their law to determine, where the limits are. And that's a difficult thing to do when things move fast. And I think the real risk to this space without new law is that regulators overreach or appreciate the subtlety and the technological sophistication. But I think one of the things that's really happening at bottom is the agency needs to wrestle with what a security is. An investment security is a term of art that has a very broad, far-reaching definition in statute and an even more convoluted understanding under case law that has interpreted that standard. And the dominant test for what an investment security is in the US is known as the Howie Test. And one of the elements of the Howie Test is that the activities of the enterprise are carried out by the efforts of others. And agency, reliance on third parties, is a core concept of a security. You don't own a security if your actions materially impact the performance of the entity. And it's really difficult in DAO space to really understand not what this thing says on paper, but really how does it function in practice? Because that's what agencies are looking at. So they're looking at, how disassociated my token governance is of the DAO's ultimate decision to do anything. And this isn't unique, by the way, to DAOs. This is true of investment clubs. It's true of LLCs. It's true of partnerships. It's a fundamental question of how much meaningful actual power does any one person have within an organization to affect that entity's performance vis-a-vis the instrument or interest that that person has. Now, that's a shorthand way of saying, what does the business do? Does it just manage assets, or does it have, business interests and activities? And what is a particular, what are the kind of principal interests in that entity, and how are they exercised? And that's constantly a moving target. So unfortunately, agencies are looking at this through the lens of harm and complaints. They're looking at this through the lens of something went wrong and they've got to unravel that. And that's unfortunately how law is created. And when law is created in that respect, it sweeps over the industry, and it ends up sweeping in a lot of benign, well-intentioned entities and people. And that's just the fact of how law is created.
Interesting. And so now there's kind of a number of states that are proposing, or another number of jurisdictions that are trying to propose new, I guess, in your terminology here, legal wrappers that essentially try to navigate this gray area to support both founders and investors. And one of those is Wyoming, which over the summer instituted this new law that allows the creation of DAO LLCs. Does that solve some of the kind of conjoined viability that you're concerned about, and the fact that many of these kind of existing entities are skirting securities law and this 200-year history of law that's been developed to essentially protect both investors and management?
I think Wyoming is an interesting start, but I don't think it's anywhere close to where the law will end up or where we ought to be from a personal perspective. I mean, the chief difference, as I understand the Wyoming law, is that the LLC, it's an LLC that recognizes protocol-based operating agreements or protocol-based design around management. And that's fundamentally at odds with the law of organizations anywhere else in the United States, because the law is created around legally recognized relationships between people. And by people, I include institutions. This is one of the first ways that the law now recognizes protocol and essentially algorithmic computed outcomes as a legal stakeholder. And I don't know that we fully understand the implications of that, right? If we're going to give legal significance and protection to algorithmic design, we're making it very difficult to trace liability and accountability back to people who are principally responsible for decision-making of traditional legal organizations. So I don't know that we fully understand the implications here, but I've heard a host of critiques about the law. One critique is that why not just do this under an LLC statute as it already exists? That's one critique I've heard time and again. And the other is that I think a lot of the terms of art there are insufficiently defined to really understand how a controversy would play out in court. And that's fundamentally what statutes are there to do, is give clarity around how things should be resolved if a legal dispute arises. I don't know that we know that fully. So I think the act is a start. It's inspired other efforts. Colorado's in the process of drafting its own DAO statute. But I think, like anything, we need to see kind of some biodiversity in the legal landscape to understand, how use cases play out and create a little bit of a petri dish of legal testing to see what's working better and why. It's very similar, frankly, to the way that co-op laws developed starting in, the 20s, 30s, and then at different periods since then.
And so with a skeptic hat on, what does the DAO bring to the table? Because it seems that a lot of what you're saying is that, look, this is a new form that that doesn't kind of jive with a lot of the existing legal jurisprudence, and founders are essentially setting these things up quickly and seeing viral growth, but really ignoring a lot of kind of the lessons of ways that companies or organizations can kind of go south. And so what does the DAO bring in your mind that these traditional structures don't have? And do you see kind of a role for the legal entities that are being developed, whether it's Wyoming or Colorado, or there's now a couple other states, I think, that are exploring this, that build on kind of the traditional entities we've seen thus far, the LLC, the S Corp, the C Corp, or even I think in many cases, some of these DAOs approximate a nonprofit organization.
Some do, yeah. Well, I think one is, I think the DAO misses the opportunity to ground a technological advent in existing law. I think there's such, this is kind of like post-Occupy rebellion against legal norms and permissionful systems to create the antidote, thinking that we have more power to kind of circumvent legal accountability than we really do. So the first thing is, they think that we need to go into this with some humility, that whether we like it or not, a DAO is a social construct and a technological construct, but it has and it will be enforced under an existing legal analog. So we can either, accept that, or we can continue to resist it and see all kinds of unexpected, unforeseen outcomes. So then the next thing is, let's identify and invest in the work to ground these, at least in intentional legal systems. And I think there's significant overlap between the DAO construct and the cooperative entity type because of the participatory economics and democratic governance. And we have so far worked on half a dozen to a dozen DAO co-op hybrids where we've nested the DAO concept and kind of governance and economic tokenomic system into a cooperative legal wrapper. What that does is it creates some kind of predictable way that the thing will operate. It creates real legal accountability and, as a corollary, real meaningful legal protection, legal liability protection. They're also more financeable because a legal entity, at least through the eyes of investors and securities regulators, is more robust than this environment of people and institutions putting significant cash assets into these DAOs that are essentially, at some level, completely unregulated, unregistered investment companies. And so I think the sooner we can nest these things under protected, recognized legal entities, it won't be forever, but at least for the time being, there will be more significant legal predictability and protection. And I think that's important. I'm hearing about just the flows, the billions of dollars of flows of capital through and around these DAOs, which are completely unregulated, in many ways unincorporated, with with legal protocol that itself is, susceptible to hacking and manipulation. And yet again, those things are going to there's going to be significant dampening effect when any of those controversies or issues end up in either, the hands of Congress or a court or even the press. And this stuff's still relatively esoteric. It's not yet mainstream enough to really have the eye of regulators and Congress on it, but that's not far off.
Yeah, especially as we move towards kind of a macroeconomic environment that's tightening, right? I mean, when the world's awash with liquidity and everything's going up, people aren't concerned. But as soon as kind of people start losing significant amounts of money, I guess the question I would ask is, if these are unregulated investment companies, do investors that invest in these DAOs, if they're not incorporated, have any sort of recourse or not really?
It's an open question. I mean, this is what I mean by saying it's a really unpredictable and amorphous relationship to define. And so that puts everyone at risk. It's very hard to understand what the expected obligations are, what the expected benefits are. And so, people harmed by these investments in DAOs have, their rights are not constrained by a contract or by an understandable, applicable set of laws. So that in some ways means it's blue ocean in terms of legal claims, legal strategy. It's blue sky in terms of, what kind of regulatory oversight a DAO might fall into. So unfortunately, these things we're at the whim of the facts as they materialize to see how these things end up playing out. And that will be the story that defines how these things get regulated. That's just how this works. So if we have, a set of bad facts that give rise to really overreaching regulation, well, now we, have to live with that. And I think that the sooner we can, again, at least temporarily nest these things under well-recognized legal norms and legal relationships, the safer everybody is in understanding and defining kind of what the lanes of the highway look like. And at least, it's like we say, you can either subject this to less knowledgeable, Congress people or regulators, or you can take matters into your own hands and define those things legally yourself. And while it may seem permissionful and exclusionary and limiting to do that now, it avoids a host of unknowns. So I think we've embraced this limitlessness today, but I think we're discounting, what that means when claims come down or regulation comes down. I think we need to understand limitlessness comes with some, unknowable consequences later.
Cool. So actually, Jason, I want to back up a little bit on the co-op thing you just started talking about, how you or your firm has worked to kind of structure DAOs and co-ops or any sort of hybrid structures. Can you first kind of tell us a little bit about we have a lot of diverse listeners. So can you tell them what a co-op is? Maybe in your jurisdiction or maybe in the jurisdictions where you operate, what is a co-op legally and how is it sort of different from, say, an LLC?
Yeah, great question. Important to talk about that at the top, really. A co-op is in most places here in the US, a co-op is both a social construct and it's a legal structure. You wouldn't call a corporation a social construct, you'd call it a legal entity. But a cooperative is both. A cooperative, it has a series of well-recognized principles, social norms, and it is a legal entity type in almost every place in the United States. Now, entity law is the product of state law here in the United States. So a co-op, like a corporation or an LLC or anything else, is defined under state law. We don't have federal corporate law, federal entity law. In the US, a cooperative is governed by statute, and every state, for better or for worse, has its own laws on cooperatives. But it's a rich patchwork. I guess there are probably around 120 to 150 unique cooperative statutes in the United States. For instance, Colorado has 6 separate cooperative laws governing different types of co-ops: housing co-ops, energy co-ops, general co-ops, etc. A co-op is fundamentally governed by democratic governance, one member, one vote, patronage-based economics, meaning participatory economics. The more one uses or consumes or produces through a co-op, the more it earns back in profit sharing. And another is sovereignty and independence. These are generally regarded as self-regulating entities. They are either corporate entities or unincorporated entities. So that means if they're corporate, they have to adhere to certain formalities like boards of directors and other things. So they're fundamentally a specific type of entity governed around these social principles. And every co-op law that exists in some way touches on the social principles of being a cooperative. Some statutes even say these are technically quote unquote nonprofit entities. It doesn't mean that they're tax exempt. It means that their mission, their purpose is not to carry on for profit of investors, but rather to carry on for patronage of its members. So, they have social purpose. It's one of the original benefit entities in the US. because these are legally incorporated entities that have as a purpose something other than a generation of profit for investors.
Got it. And so like if you're a DAO and, part of this, you've hinted at some of this, right? Some of it's just like we get to move faster. The voting structure is captured in our software through the thing that we use for free, right? Not for free. Obviously, you're paying for gas fees and all that. But why should DAOs, in your opinion, how are they a good fit for co-ops, basically, right? Like, because there's been a lot of writing about this recently, and a lot, I mean, relatively, maybe 3 or 4 pieces in the last few months that have kind of blown up where people are like, co-ops are super interesting. It's like everyone's just rediscovering this movement that's been around for 100 years, right? So like, why should DAOs care about co-ops? You kind of gave us a few reasons, but really tell us why, like, if you can.
Yeah, I mean, so I talked already about some of the legal benefits. Another is a lot of, DAO world is probably recreating the wheel. There's a strong emphasis on custom design around tokenomics, governance, and there's a cost associated with that development and, self-described innovation. There are analogs that give you guidance, that get you further downfield. And I think the cooperative is in many ways, at least a starting point for DAOs to recognize, the law actually recognizes a lot of this stuff already. Mm-hmm. And it's not just a legal wrapper, but it's a guideline, or it's a starting point for DAOs. I think co-ops will innovate. There's a need for co-ops to really get back to their core business of innovating democratic governance. And DAOs have added a lot to that. And technology has added a lot to that. Co-ops have really struggled in the last 5 years around governance tracking and patronage tracking. There's a lot of technology problems that co-ops have faced. I think DAOs present a lot of solutions for that. But likewise, I think this is about the mergers of the waters. This is like the river and the ocean meeting in the delta. And it has to be bilateral or multilateral. It can't just be about, DAO world learning about co-ops. And it can't just be about co-op world learning about DAOs. It really has to be about the mixing of culture so that we can mainstream this stuff. And, I, for one, have not been able to really wrap my arms around the DAO side because it is so technical and, wonky. My colleagues have. Yev and Jacqueline are the DAO co-op experts, in our firm, and I think increasingly throughout the country. And they've done that hard work to blend vocabulary, blend structure, and they're pushing the envelope in some really impressive ways. And I think they're giving tools that allow these DAOs to be more durable.
Let me just jump in here, Chad, 1 second. So one thing I want to ask here, just from gaming this out, Jason, if I'm a founder and you're telling me that the SEC doesn't have the time or the money to regulate me, and I've got kind of a fixed amount of time with this kind of liquidity explosion where everyone's just printing money, doesn't it make more sense for me just to go with the DAO and cross my fingers and hope I'm just not one of the ones that are regulated before, this house of cards falls apart? I guess what I'm hearing from you is that the cooperative structure, the legal wrapper for the DAO, helps to limit the liability of the founder, helps to limit the liability of the management team, provides these investor protections, but it still comes with these elements of the cooperative model that have been sacred cows, for instance, one member, one vote. And I'm wondering if you think there's a need for innovation around any of those kind of traditional things that have limited access to finance, or if you think that the world is kind of adopting or moving towards a zeitgeist where one member, one vote is going to be more tolerable to risk capital.
So, I hear the preference for agility and lean design when there's a temporal nature of the opportunity. If the time is now and you're building something, you're building for the today. And I think we know what that means. Very few entrepreneurs really think to invest and build for success. They're building for one step at a time, and then they're the product of their own success. And what does the norm around that look like? Well, it looks like people who've diluted themselves out of control of the company. They get ousted, or they end up, with all kinds of unforeseen and adverse consequences vis-a-vis the funders or their investors. And I understand that. And yet we're dealing with such immense sums of capital that there's no world in which, these things both accumulate and vanish without any accountability or, analysis, or at least a desire for transparency. And I don't think it's about personal liability really as much as it's not, am I the subject of new regulation? Is whatever regulation emerges going to come down on me and have an adverse impact? Or if something bad happens, is that going to trigger enforcement by regulators under existing law? Regulators don't have the time to really dissect what this new species is. And so they're going to look at it in the most conventional way they know how. And they're going to draw those conclusions about what this is. They're going to be painting all of this in a conventional way. And that usually means they're going to take a blunt instrument to something that otherwise is the product of finesse and, elegant surgery. And that rarely has good outcomes for anyone. When, regulators are taking blunt swords to something that really requires a surgical scalpel. And, with the amount of money flowing through these things, I really think that there's an inevitable day of reckoning when accountability will be demanded. And I don't just mean this globally. I mean this, in individual use cases. And as somebody who is even thinking about participating in these things, not knowing what my legal exposure is for, the activities of the DAO itself, that just gives me concern as a potential investor, as well as a potential, decision maker. I just come back to the idea that blue ocean is not all opportunity. There's, a balance there. It's opportunity and risk. And it's scary that we don't fully appreciate or even know what that risk looks like and how it materializes. So when that day of liquidity is over and we're seeing the downswing, a lot of people are going to lose a lot of money, and a lot of people are going to come under scrutiny, and a lot of DAOs, good, even functional DAOs are going to come under scrutiny in ways they didn't expect.
Interesting. You're making me concerned for the investments that Jahed and I have made into DAOs and whether or not we are technically kind of part of the team and if we have conjoined liability. I don't think we do, Jahed.
Note, nothing on this podcast is financial advice. We are not fiduciaries.
Yeah,
Thank
absolutely.
You very much.
These are just musings of, a lawyer doing adjacent work. So you're right. Don't take this to the bank.
Yeah, just we didn't start with that, and I figured now is a good time to remind everyone this is not financial advice.
Or legal advice, yes. Yeah.
So, Jahed, I interrupted you. I don't know if you want to kick in here, but I wanted to fall on this thread of kind of decentralization and this idea of, when is the right time for a founder to decentralize? I know that, Jason, just in knowing you, we've dealt with, our own kind of experience, issues of management control, issues of governance. And when do you think is the right time for a founder to say, okay, this is the right time to kind of tokenize my company or to empower the community? And when is the right time to kind of maintain that tight-fisted control? I know in a lot of your work, you're working in kind of a cooperative structure, but your experience with Stocksy, I think, offers some insight because the board is really still controlled by not by insiders, by people that are very, very kind of closely tied to the firm. My understanding kind of the Stocksy structure has 3 classes of shares. One is owned by the photographers, one's owned by the original founders, and one is owned by the employees in the firm. And so they've put in some design principles into this kind of traditional cooperative structure that doesn't fully decentralize to its photographer. So given that you've sat on the board there for a while, if you were coaching a founder that's gone through seed or going through Series A, like at what point do you think that the company is robust enough to actually support a move towards democratic governance without creating impediments for future access to capital or impediments for efficient decision-making in kind of competitive fields?
Yeah, I have to take that question at a more specific level. The Stocksy experience is in many ways impractical as an exit strategy because unless there's a wholesale buyout, so I don't look at Stocksy as the destination for a venture-backed emerging growth company. It's too unpracticed and there's too much novelty to their structure. And there's probably, this is one of my curiosities, if not kind of concerns, skepticisms around exit to community, is that a lot of the ventures we're talking about are so highly capitalized that it's neither appropriate nor even beneficial to think about liquidating existing investors into a democratically managed or multi-stakeholder managed entity because of all the changes that need to be made. I mean, you could topple an otherwise well-functioning, well-managed business. So I look at Stocksy. I mean, one is they started this way. They had and most of the multi-stakeholder co-ops I form, and I've probably formed more than 40 of these things in the last 7 years. What I've come to learn is all of these multi-stakeholder entities that practice democratic governance, they go through an intensive period of design, and there has to be this transition where they begin to own their structure and practice under real world conditions. That means building culture, practicing, reforming, revising, and recommitting. And what I've come to learn is that we will nor should we ever try to get to a place where we codify. And this is a lesson for DAOs. We should never try to codify the utopian ideal of democratic management in legal documents to a degree that removes any sort of human intervention or uncertainty. It's not possible. It will never be possible. And so all we can do is create the roadmap and the guideposts for how humans will interact and what the backstop is when there's uncertainty or controversy. But almost everything else is a function of practice under real world conditions. So I've actually begun to take a more light-handed, lean approach to co-op design to say, let's get the fundamentals down. Let's adopt some best practice around governance and boilerplate. And then let's make sure that you invest in the technical support and the cultural resources needed to practice and embed this stuff in co-op civic life. Otherwise, no written document, no bylaws, no contract can guide you. And to the same degree, I don't think DAO protocol can either. It's it's too self-aggrandizing to think that we can prescribe how that will look, how that will operate. So likewise, when we think about what it takes to convert a venture-funded entity, we need to be thinking about the post-founder management structure. We have to actually be thinking about not just the design of management and the design, who are the people or what are the skills of a role to make this successful? And I think we do so much to try to codify and get past that. I just don't hold the belief that we can ever kind of prescribe, predict, or algorithmatize governance to say, if a founding team is going to leave and we're going to exit a community, we actually have to identify and define roles so that we can begin to actually hire the people to fill those roles. It's not about, writing this stuff down and having the most elegant blueprint because it'll become impracticable or impossible to actually execute. So I'm a firm believer that this is about the fundamentals, and it's as much about logic as it is about the fundamentals and the practice. So when we think about exiting the community, let's look at the real expectations of investors on a cap table. And if the last venture round, valuation was 20 million and it was traditional investors, I'm assuming like an average exit price of $50 to $75 million enterprise value. Can we really put that on the backs of community investors? Like we can legally, but should we? Will there ever be enough value on paper, in theory, to reward those people for taking that risk, which is happening in association with reform to governance and probably a leadership transition? And I look at these things in practice because of how these things play out. Again, analog is traditional M&A. M&A is risky when there's so much uncertainty, and we often pay premiums for turning unknowns into knowns, even if it's imperfect. All that's to say, I think a lot of this boils down to just the basic fundamentals of how this is going to probably play out in the real world.
Yeah, it's interesting you bring it up, actually, because I think that not that you're looking for any fights, but I think that you're more in agreement with at least some of the more luminary thinkers in the blockchain world than people would think. Because basically, you just remind me of something that Vitalik wrote a few years ago. He was talking about the perils of on-chain governance. and how like basically everyone's talking about, Bitcoiners will be really into, specifically Bitcoiners are very much into like, this is why Bitcoin is great. Everything is immutable. It's on chain and the agreements are there forever. But the real actual way that things get there is the problem, right? The social layer of governance. So Vitalik wrote this really great piece on how on-chain governance is super overrated and that much of governance actually happens in the murky world of social relations. And so like, this kind of, I'm going to put some words in your mouth. You tell me what you think about this. There's a provision in the Wyoming law, what we were looking at a few months ago, that basically says something effective like, is your DAO managed by members or managed by an underlying smart contract, e.g. algorithmic, right? So like, I would venture, basically, if I was doing this today and I was a founder, I would absolutely check the box for managed by members, right? That's just the way that I think you would want to do it, because you don't need to be, there's so many, like code captures so little of the richness of social interactions. And I think you give yourself optionality for the future. What do you think about that?
That all resonates. I mean, I agree. I think that, code is getting more sophisticated. And I think we can begin to appreciate what I kind of, analog world call like multivariate decision-making, but humans are innately programmed for that. I mean, we have to dynamically weigh various considerations at different weight levels and also build consensus. And I think that really can only happen through communication and trust. And I just don't see protocol ever getting us to a place. I say the same thing about collaboration. I just don't see how you can build a healthy culture through systematizing decision-making among people. There's just too much richness of debate, of the human experience, of different perspectives that requires communication, requires trust. And I think in some ways we're trying to bypass that because we live in a virtual world that is flush with liquidity. And, we're trying to create opportunity across borders and across, so many things, but we're in some ways losing the richness of that human experience, the human connection. And some of the hardest decisions I make require empathy and trust and a sounding board. I can't just distill it to a binary, this
agreement
or
engine.
that.
Yeah, exactly.
Sorry, you were muted there. What'd you say?
Oh, I was just saying you can't distill it to like an agreement engine, which is the way a lot of these people think about it, right? Like,
no, I absolutely agree with that. And that's why I say I design co-ops now to be fairly lean. And I say, use this to get started. Don't use this as a crutch to avoid doing the hard work of building a board, creating practice, creating culture. That is the essence of organizations. I heard this on another podcast. Organizations are merely groupings of humans. Yes, we buy assets, we exploit assets. Yes, organizations live in buildings, but what are they? They are fundamentally about people and organizing groups of people to communicate and carry out activities as people. And I think if we try to lose sight of that, or if we try to distill that or remove agency, again, I go back, this is not only risky, but dehumanizing. And I think this is one of the things that I really appreciate about cooperatives is that it's merely a blueprint for the highest ideal of human interaction. To believe that we're agents of free will that can come together to solve our own problems and maximize pursuits for our own needs in a democratic fashion, where every voice is at bottom equal and where ideas rise to the top through rich discussion. I think it is one of the last vestiges of true meritocracy. And I'm not a believer that meritocracy inherently exists because of historical systems of oppression and power. But cooperatives are places where we can at least begin to hope and practice that.
And that's kind of where I think the values of the space kind of deeply coincide with co-ops, is that, if you're in the right circles, it's not all this way, but basically that's where this stuff is coming from, right? It comes from a place of like, there is another way for us to imagine this world. There's another way for us to rebuild it. And we are trying to co-build, co-design the tools to bring us there together, right? So I think if there's one thing, at least for me, I'm not wrapping things up yet, just for me to take away from this little exchange though, is that you can at least maybe do it in a way where you're not going to get sued.
What I like to say about that is, like, if you're getting sued, umpteen things have gone wrong. Safeguards have failed. This is the beginning of creating predictability and intentional expectation management. So that means you are creating the safeguards to avoid unpredictable outcomes. And I think that's actually goes back to the human experience. We as humans crave an understanding of where we fit in, where we can add value, what we can do, within bounds. And I think that is important. I think to understand the legal significance of a relationship is important for us to manage expectations, which is one of the most important safeguards to the breakdown of trust.
Awesome. So well articulated. I wonder if we should end on that note. I guess, Jason, the work you're doing now, maybe you want to talk a little bit just at the end here about the work you're doing with Main Street Phoenix Worker Cooperative and in addition to that, where people can find you online and stay on top of the exciting kind of ideas that you're coming up with. And you continually are blogging and tweeting about some of the work that you're doing once it comes out and is more public on organizational design. So tell us a little bit more about Main Street Phoenix Worker Cooperative, and then maybe we should finish out with how people can stay in touch with you and follow you.
Yeah. Well, this is very much about the material or the physical world here. So the Main Street Phoenix Project is a management hospitality group that's organized as a worker co-op. We launched this, I conceived of this 2 days into COVID lockdown, March 20th, 2020. And the idea was to create a turnkey solution to the crisis of business closures and employee ownership conversions by building the team, the capital, the resources, and the knowledge to streamline, simplify, and accelerate conversions to employee ownership instead of tackling this one business at a time. And so we are a turnkey solution to sellers looking to leave a legacy and transition their business to employee ownership. We closed our first deal right before Thanksgiving. We did a deal in under 30 days to buy, and we now own a coffee shop. We went public early last week. It's called Griffin Coffee in Denver,
Nice.
Colorado. We're working on our next set of deals. We'll hopefully have 5 deals done in 2022. We're looking to build an employee-owned group that will at scale own 25 or more independent locations. The workers come in and are eligible to become owners at the holding company level. We have a WeFunder campaign that's currently raising money. You can find that on WeFunder. Look up Main Street Phoenix Project. The Main Street Phoenix website is undergoing a renovation. It's mainstreet.coop. And what I do in my day job is build creative entities like this. You can find me at jrwiener.com. That's jrwiener.com. Our blog is really active with what we're working on and talking about some of these structures as well. And you'll find lots of resources on DAO co-ops. Stay tuned because we're developing a program, a cohort program for DAO co-ops to go through essentially, it's not an accelerator, but it's kind of a design program to accelerate the creation of a DAO co-op blueprint that can then become build ready with the support of our team. And that should hopefully be piloting in January.
Oh, cool. Okay. And that's, people can find out more on your main website?
That's right.
Awesome.
jrwiener.com.
Cool.
I'm on Twitter. Awesome. We're on both our firm and I am on Twitter, LinkedIn, Instagram, but Twitter is probably the best place to connect.
Awesome. Jason, thanks so much. It's always awesome to catch up. Really appreciate your time and all the work you're doing in the space. And looking forward to talking to you again soon.